speak to them outside the conduct of the hearing regarding this issue. They are not permitted to speak to you or to anybody regarding this issue outside the hearing. We're going to go through and have the objectors who did not have a chance to sign up to be an objector. I think there were a lot of people here last week that could not hear what was going on because of the size of the room and the number of people that we had. That's why we're in this room tonight. Anybody who wasn't here, anybody who was here and didn't get a chance to sign up and has decided they want to sign up as an objector will have the opportunity to come forward to complete a form as an objector. That makes you a party to the hearing tonight. It gives you the opportunity to present testimony and to cross-examine any witnesses that are called. After we take care of that, we're going to have Jim Murphy from the Planning Commission give his report and report on the Planning Commission's recommendation. Then we will have the applicant present their application, calling witnesses that they wish to call. Then we'll hear from the objectors. The rules that apply to this hearing under the zoning ordinance and the municipal planning code require that the applicant have their first hearing and a chance to present their evidence within 60 days of the date of the application. We're within that 60 days. We talked about that at the last hearing. The 60 days expires Friday. That's why we're here tonight. We are going to hear their evidence tonight, and then we're going to start to hear from the objectors. The objectors, after the applicant has closed their case, the objectors have a total of 100 days in which to present their case. Each subsequent hearing from tonight has to be conducted within 45 days of tonight. So I'm anticipating, given the number of objectors that we have, that we may not finish tonight. We're going to go tonight until about, the plan is go until about 8:30. And we'll see where we're at, see how many objectors we have left. If we think that we can get it done in an expedient fashion, maybe if we can get it done by 9 o'clock, we continue. If it looks like we're going to be here significantly longer than that, which, to be honest with you, I anticipate, then the hearing tonight will be concluded and we'll reschedule a continued hearing for a later date. But we'll cross that bridge when we get to it. So I guess the first order of business is, if you are an objector that has not yet signed up and you wish to sign up as an objector, I have the forms. We need your name, your address, and a phone number. If you can come up and you can complete a form. Is there anybody who was here, who was either not here or was here who did not sign up that wishes to sign up as an objector? Please come forward. Excuse me. No, not yet. Does everybody who wishes to sign up as an objector have the opportunity to come up and sign up as an objector? I have all of the documents that were submitted last week. I did receive today Laura McGarry, who's here in the front row, submitted a withdrawal of her party status application and then entered her appearance as an attorney for objector Susan McNally. So we'll accept that into the record. We'll accept her withdrawal of party status, and we'll accept her entry of appearance on behalf of Susan McNally. I have a couple of housekeeping issues as far as documents are concerned. I'll have marked as Exhibit 1 the application that was filed by Scranton Materials LLC, 3-page document. It is a zoning hearing board application. It is a list of adjoining property owners, and it is a map. I have the applicant's proposed ordinance. We'll mark that as Exhibit 2. It is a 10-page document entitled An Ordinance Amending the Township of Ransom Zoning Ordinance adopted January 2, 2012, creating the Data Center or DC Overlay Zoning District, including definitions pertaining to data centers in Section 302 of Article 3, adding Section 406 to Article 4, allowing data centers as use in the Data Center Overlay Zoning District, and amending the Township of Ransom zoning map to create the Data Center Overlay DC Zoning District. I have that marked too. I have Exhibit 3, which is certification from the Scranton Times that the hearing that was scheduled and conducted for January 15, 2026 was advertised in the Scranton Times on December 30, 2025, on January 6, 2026, and on January 13, 2026. We'll have that marked as Exhibit 3. I was not able to get, because of the timing of tonight's hearing, I was not able to get a certification from the Scranton Times indicating that that tonight's hearing was advertised. It's my understanding that it appeared, the advertisement for tonight's hearing, it's my understanding it appeared in the Scranton Times, I believe on Friday and Saturday, and I have a copy from today's paper with the notice that appeared in the Scranton Times. I will receive from the Scranton Times, and we can enter into the record at a later time if there is a later hearing, the certification from the Times. But I'll have this marked. This is today's advertisement of the hearing marked as Exhibit 4. I noted at the previous hearing that the Lackawanna County Planning Commission had not provided a report on the proposal. It had been submitted to them, and it was anticipated that they would provide a report to us following their next meeting. I received, and I'll have marked as Exhibit 5, a draft report received this afternoon by my office, by the township office as well, from the Lackawanna County Planning Commission ordinance amendment evaluation report from the Planning Commission of Lackawanna County, indicating that the ordinance verbiage was submitted to the office for review, but they had not yet received the proposed zoning map illustrating the location of the overlay district, and that they required that in order to make a recommendation. I will indicate that I did submit that to the County Planning Commission this afternoon after receiving their email requesting the additional information. So that's been submitted to them, and we'll wait to see what they say. We'll have that one as Exhibit 5. At this time, I would call James Murphy from. Can you state your name for the record?
My first objection is to the notice for this hearing. Pursuant to, from what I understand, and that's part of my second objection, this is a request for an amendment to the zoning ordinance. The municipality's planning board, the MPC, sets forth explicit directions for the posting and notice of an amendment to the zoning ordinance in section 610. Specifically, the text of the ordinance or substantive summary of the ordinance should be contained in the notice and advertised in the newspaper. The notices that were just entered into evidence as part of this proceeding did not contain such an inclusion of the text or reference to where the text would be made available. And on that basis, my objection is that this hearing was not adequately noticed to the public.
Sure. Response?
That's, you're the one that set up the meeting, well, you guys filed all the notices and stuff. We as Scranton Materials had nothing to do with that.
All right, and before the board is a request for a change in the zoning ordinance. It's not we're not here to pass a change to the zoning ordinance. So I think if there's a change to the zoning ordinance, you may be correct, but for the hearing tonight, I think that the notices are appropriate under the requirements of the zoning ordinance of Ransom Township.
So I think my follow-up to that would be then to get specific clarification on the nature of this hearing and under what provisions of the MPC or the local zoning ordinance we're proceeding if the understood outcome is that this isn't going to result in an amendment. What are we here for then?
We're proceeding under Article 12, Section 1201B6 of the Ransom Township zoning ordinance, which provides where an applicant feels that the zoning ordinance is in need of a change in any part, the applicant may petition the Township Board of Supervisors to consider an amendment to the zoning ordinance. Such a petition shall be referred to the Planning Commission and County Planning Commission for their recommendation. The Township Board of Supervisors shall then, after public notice, hold a public hearing on the proposed amendment. After the hearing, the Township Board of Supervisors shall make their decision on the proposed amendment. If the amendment is adopted, the applicant can then proceed to apply for a zoning permit in the manner applicable to the type of use that the applicant wishes to propose. So at this point, we're not at a point where we are amending. We're hearing their application. There'll be a decision made, and at that point, the appropriate advertising would set forth following, and there'll be a public vote on the amendment.
So if there is a grant of the application before the Board of Supervisors, is it the position of the board that there is no amendment, that the procedures for an amendment under 609 of the municipality's planning code would then be initiated. And if that's the case, I would like the applicant to confirm on the record that that is their understanding and that that is their expected outcome of this case, because I don't believe that the provisions of 1201 of the zoning ordinance would allow for that type of consideration. I believe that a grant of the application would result in an amendment of the zoning ordinance that creates a law in Ransom Township that would require additional legal actions to withdraw, to cancel out. So I'm still unclear as to the basis of this hearing and what the potential ramifications are should the board approve the application.
Do you agree with the procedure that I've laid out?
Yes, Mr. Marshall.
So at the end of this hearing tonight, the outcome, if it's granted, if it's denied, it's denied. If it's granted, it's the position of the board and the applicant that then they would submit a request or a petition for an amendment under section 609. Who would be initiating it?
If it's granted, then the amendment would be advertised and then a decision on that amendment announced at a public hearing.
There would need to be a public hearing on the proposed
Not a
amendment,
public hearing, a public meeting.
which would still offer the opportunity for the public to be present.
And comment, but not provide testimony. It's a meeting and not a hearing. Tonight we're here for a hearing.
If the record clearly reflects that the applicant is not going to proceed and that this is not going to result in the amendment of the zoning ordinance, I'm satisfied with the manner of proceeding. I am concerned that the nature of this hearing could be perceived, if on appeal, as being the type of hearing that would result in an amendment should the applicant pursue that avenue on appeal.
And they've indicated they're in agreement with the procedure that I've outlined.
That regardless of the outcome tonight, there is not an enacted ordinance or amendment that would allow for the building of the data center that they're discussing. They would have to come back and
It would
go
have to
through
be
this
submitted
process again.
for a meeting. It would have to be advertised and submitted at a public meeing for vote by the supervisors after comment from the public.
That's our agreement and understanding, Mr. Conlon.
And there's no basis for objection at that point if that's the understanding. Other than that, this feels duplicative in that we're all going to be back here and making the same statements and comments again whenever this amendment comes before the board.
And the ordinance requires a hearing, and that's why we're here for a hearing.
So on what basis, under the MPC, what is this? Is the board acting in a legislative capacity or are they acting in a quasi-judicial capacity? And if the outcome of the hearing is to deny it, what remedies, or if it is to grant it, what remedies exist for whoever is aggrieved?
That's not for me to answer.
Okay, as long as everybody's in agreement that there's not going to be an amendment after the hearing concludes,
I think we are in agreement to that.
We agree that we're going to follow whatever procedure comes next pursuant to the board, the MPC, and the township.
as long as that's on the record, I'm
It is.
satisfied.
Okay.
Kevin, can I just interject one thing? Because at the last meeting, we did exhibits. We went out of order, but you added exhibits tonight.
Those are not your exhibits. Those are Board of Supervisors exhibits that I've entered into the record. You'll have an opportunity to enter all of your exhibits.
Okay. Well, and I just want to be clear, because we entered those 8 exhibits at the last meeting.
I don't know that you did. We never got to that point.
They were not, okay. Okay, so she has the documents and we'll enter them in later.
Yeah,
Okay.
they were never admitted into the record at the
Well, then
last.
the only thing is I'd like to have them admitted if we're going to ask questions of Mr. Murphy. Because there may be documents in here that I may need to reference depending on what his testimony
All right.
is
And those are the 8 exhibits that were submitted.
at the last meeting.
Okay. Well, why don't we just have them identified at this point, and then when you're called in your case in chief, you can ask to have them admitted, and that'll be subject to any objections by any of the objectors. Okay? So, we're going to identify, for purposes of the hearing, Petitioner's Exhibit 1, which is the proposed zoning overlay ordinance. Petitioner's Exhibit 2, which is the application that was submitted. Petitioner's Exhibit 3, which is an email dated December 1, 2025. Petitioner's Exhibit 4, which is the zoning overlay map. Petitioner's Exhibit 5, which is a letter from my office to Mr. May and Sola regarding the hearing on January 15th. Petitioner's Exhibit 6, which is a survey map. Petitioner's Exhibit 7, which is an aerial map. And Petitioner's Exhibit 8, which I don't have a copy of, which is the Ransom Township zoning ordinance. So those have been identified for purposes of your cross-examination. Thank you. Okay, so at this point, we're going to call. Okay, I have a written objection from Mark Bazzacco. You, Mr. Bazzacco. Okay, I've not had a chance to review this. Okay, so just so that I'm clear on the record, Ms. McGarry, just so that I'm clear on the record, your objection to proceeding has been withdrawn, correct? Just want to make sure that we've ruled on whatever objections are outstanding before we move forward.
My objection is wrong because the record reflects the understanding of the party as to what.
I think it does.
Wait, no, I have two objections.
Right.
First was to the posting, the notice, and insufficiency of efficiency with respect to the inclusion of the land of the amendment. That's the first.
Okay, and is that still outstanding?
That's still outstanding.
Okay, and just so that we're clear on the record, I would recommend that that objection be overruled. So, how do you vote? Overruled. Okay, so your objection is overruled. It's noted for the record, but overruled.
My second objection is to the form of the hearing, and by way of the jurisdiction of the board, it is not a hearing for amendment. The jurisdiction of the board of supervisors should hear whatever this hearing is under 1201 of the Ransom Township zoning ordinance. However, if it is on the record that an understanding of the board and council for secretary of the applicant that this no outcome of this proceeding should result in the amendment of the zoning ordinance
Without further steps.
without steps of compliance to the MPC should require another hearing, public hearing as defined in the MPC and the Ransom Township zoning ordinance. Then I consent. I
Okay.
want to clarify that both the MPC and the Ransom Township zoning ordinance define public hearing as a defined term. I don't know that there is necessarily a distinction for what we need, but if that process is going to be followed, then
And that's what they've indicated, and that objection is therefore withdrawn. Okay. And Mr. Bazzacco, I have your objections. The first is lack of jurisdiction. I think that I addressed that during the discussion with Attorney McGarry regarding Article 12, Section B6, and I would recommend that the board overrule that objection. Overrule. Okay. So the objections that you have, do you still want this written into the record? If it's withdrawn, I don't see the need for it.
On record, if we're not passing any amendments or
Well, and just so it's clear, there wouldn't be another hearing. The passage would be considered at a public meeting where there would be a time for comment. Okay. Correct. All right. So, We'll call Jim Murphy from the Planning Commission to testify. Yep. Can you state your name for the record, please? Okay, Mr. Murphy, are you on the Ransom Township Planning Commission?
Sure.
Speak up.
I'm the chairman of the Ransom Township.
Is that on? Give it a tap. Oh, yep. Okay. Did the Planning Commission conduct a meeting concerning the application of Scranton Materials for a data center overlay zoning district?
Yes, we did on 1/12/2026.
Okay. And were there meeting minutes prepared in connection with that meeting?
I believe there should have been by the township secretary, yes.
Okay, I'll hand you what we've marked as Exhibit 6 for purposes of today's hearing. Is Exhibit 6, are these the meeting minutes?
Yes,
Okay.
that
And-
is correct.
That's Exhibit 6. What were the findings of the Planning Commission with regard to the proposed zoning overlay district?
Well, we were, at that meeting, we were presented a concept plan dated 12/12/2025. It was submitted to the planning commission, and I have some general notes. On that drawing, there were 6 buildings proposed. They're 214 foot by 732 foot per scale in the drawing, with 120 foot maximum height per the ordinance. Buildings appear to be about 250 foot in elevation between the lower 2 buildings and the upper 3 buildings. The upper 3 buildings to the last building appear to be another 100 foot in elevation going uphill per retaining wall max height and spacing per your drawings. There's an SWM, a stormwater management pond. It's about 446,500 square feet, meaning it's about 250 feet wide, about 893 feet long against a 50 foot retaining wall. Per code, these are usually about 2 foot deep. I'm thinking it's going to be much deeper than that. Second stormwater management pond is about 737,697 square feet. It's about 927 feet by 711 feet. It's an irregular shape. It's against 2 50-foot retaining walls. Usually these are a minimum of 2 foot thick as well. Both stormwater management ponds will contain probably at a 2 foot depth around 8 million gallons of water on top of the hill. Drawing shows retaining walls 50 feet in height within 70 feet of the property lines. Questioning, should this probably be 300 feet? Drawing shows additional properties, all adjoining properties, but no references to owners or size. The drawing references cooling towers. There's nothing on the drawings. These are noise producers. The drawing references wetlands. Again, there's nothing on the drawing indicating any of that. There's one access road through Newton property on a portion of the property. This property lays in Ransom Township and Newton Township. I'm still wondering if Newton should be contacted or be informed on possible development on the joint property, because Who knows what happens in the future? On the ordinance proposal, we read through the ordinance proposal, and 406.1 data center overlay. Number 1, 120 acres. That do not encroach or disturb, infringe on any wetland or waterways shall also be free of protected or endangered species habitat. It's not in there. Generators shall comply with noise ordinance. The 120-foot height, does that conflict with airspace and the fire companies for emergency services? Buffer requirements, page 4, reference DEP requirements for buffers that are consistent with protecting waterways and wetlands of the Commonwealth. Page 4, numbers 4, 5, and 6. Minimum setbacks, max building coverage, and max impervious coverage. Review these against other commercial industrial zoning rules. They don't seem to be in line with any. Architectural design guidelines, page 4. No to solar structures on the roof. This will make the buildings even taller. Page 6, DBA for generators shall comply with noise ordinances for the township. Even if a data center runs on public water and sewer feasibility analysis should be performed consistent with requirements for non-public water and sewer facilities. Page 7, number 8, standards requirements in Pennsylvania DEP plus all other regulatory agencies having jurisdiction, including but not limited to the U.S. Army Corps of Engineers, the Chesapeake Bay Commission, etc. Provide estimated power consumption and feasibility study with a letter of authorization. The ordinance does not include environmental and community analysis with impact assessments. Example, water, sewage, solid waste, emergency responders, etc. Those are the things that we kind of read into this, and that's the reason why we kind of said that we don't recommend it.
And the concerns that the planning commission had regarding the plan that was submitted, if the ordinance as authored by the applicant were to be granted, would any of those concerns be covered by the proposed ordinance?
Not really.
And ultimately, based upon that, what was the ultimate recommendation of the planning commission?
The ultimate recommendation of the planning commission was that they do not accept this ordinance as written.
Council, any cross-examination?
Yes.
Just make sure that you're into the microphone so that everybody.
So what I'm going to provide Mr. Murphy is our exhibits 1 through 8 for him to reference.
Okay.
And in that, you said you didn't have a copy, so I have.
Okay.
Mr. Murphy, we're going to reference.
That's the ordinance proposal right there.
Yeah. Yeah.
These are that's the application.
Yeah. So here's the color sheet. So just so we're on the same page.
Sure.
So the first thing is so the documents that I provided to you there, between the initial meeting that the planning commission had and the subsequent meeting, those are all the documents that were submitted at those 2 meetings.
Where's the concept map that you presented to us? Seems not to be here. That's the zoning map. This is the book you gave me, right? Okay. It's not a map, it's a proposed concept drawing.
Yeah. So first thing we'll do is let's refer to Exhibit 8, which is the Ransom Township zoning ordinance.
Okay.
In that ordinance, would you agree with me that it does not provide for data centers as a use? Is that correct?
I'm sure it doesn't, because when this was done in 2018, data centers were a thought.
So it does not, I just want to make sure I heard you correctly. It does not.
Correct.
Okay.
You heard what I said. Yes, does not apply to
And in there, there's no other reference of anything synonymous with data centers or anything to that effect, correct?
Last,
This line of questioning, I understand the rules of hearsay don't apply strictly. However, this is a document, a public document that I believe can speak for itself. I don't know what, respectfully, the gentleman's knowledge of qualifications are with respect to comprehensive understanding of every provision of the local zoning ordinance. The zoning ordinance is what it is, and I think the board can take special note of specific provisions and what happens that this is something.
Do you want us, Mr. Conway, do you want to stipulate that data centers are not provided for?
Do you want to move for the admission of the zoning ordinance?
Yes.
Okay. Any objection to admission of the zoning ordinance as an exhibit from any of the objectors?
Which zoning ordinance?
The Ransom Township zoning ordinance of 2018. The current Ransom Township zoning ordinance, my understanding, is the zoning ordinance of January 2nd, 2018.
It will be in 2018.
2018. Okay. So, any objection to admission of the Ransom Township zoning ordinance of January 2nd, 2018? Okay, no objection. That's admitted into the record. And as Ms. McGarry said, it's a document. It says what it says.
Mr. Murphy, I'd like to refer you to Exhibit 2, the November 25th, 2025 application. In that application, it identifies the current use as a quarry in its S1 zoning district.
that's correct.
That's correct. Also, it's showing the proposed use as a data center in the application.
Corner, it says here, current zoning ordinance does not provide for data centers as a use.
And then within that application, it identifies the proposed zoning change being overlay, correct?
Correct.
And then you have Exhibit 1 in there, which would be Scranton Materials zoning overlay ordinance.
It's the one I read.
Okay?
That's the one I just referenced to.
That's what I wanted to clarify. That's the one that you referenced.
This is the one.
Very good. Thank you. And then I'd like to reference you to Exhibit 4, the zoning overlay map.
Yes.
In that overlay, it identifies only the property of Scranton Materials, correct? It doesn't contain any other property contained within the township, correct?
It's pointing to the data center overlay zone, and it appears to me that that's the property that is indicated.
That's Scranton Materials, okay. Thank you. And to the best of your knowledge, there's no other zoning district in your experience that references data centers within the zone, correct?
I'm going to check myself, so this gentleman's not, I don't think there's been anything.
Well, he's the chairman of the planning commission, so I mean, I think he would have some knowledge of the zoning ordinance.
That's two different objections. He's the chairman of the zoning.
Planning, correct.
Planning commission. So
Planning.
saying he has no knowledge or expertise, or can't be asked about the zoning ordinance.
I think he can testify as to his knowledge.
And that's how I phrased the question. I asked it, that's to his knowledge.
And object then to the zoning ordinance being adopted.
I can overrule your objection.
So what are you asking?
So within that, there's no other zoning district that identified or affected by either the zoning overlay or the data center overlay, correct?
Apparently, it's written specifically for Scranton site. I thought we established that.
And just so that I'm clear for the record, I don't know that I understood that last question. Are you asking him on Exhibit 4? Are you asking him that the data overlay The data center overlay zone that's referenced on Exhibit 4 concerns only the S1 open space / conservation zone that's shown in the upper right corner of the map. Is that your question? Okay. And is that your?
It's pretty clear, it's written right here. I don't know why the question is asked.
Well, because procedurally we have to enter certain documents into evidence. That's
I understand, well, there is.
Now, can I just ask clarification? On that exhibit, the blue slash lines are the data center overlay zone, correct? In that upper right corner?
Yes, I believe that's so.
Is that right?
It's not shown only in the green section,
That's
it's
what
shown also in the R1 rural residential zone as well.
So it does go into the rural residential zone as well, is that right?
It's the way they got it hatched, cross-hatched, I would guess the guy that did the map is on the ball.
Okay. Go ahead.
Next exhibit I'd like to draw your attention to is exhibit number 3.
Solicitor letter supervisors here. Okay.
You have exhibit 3 there, Mr.
There it is, number 3. I'll just start it back, mark in the corner.
So the subject of the exhibit 3 is addressing the submission of the application for the December 15, 2025 Planning Commission. Correct.
This is just telling us that the planning commission meeting was scheduled for December 15th.
Okay. And then you chaired that meeting, correct?
Yes, I did.
And then at that time, the first meeting, December 15th, your township engineer was present, correct?
Correct.
And he asked that a satellite map be submitted, correct?
Yes, you did.
Do you have exhibit 6 that you said earlier you may not have it?
These are the satellite maps that were presented at the 12th of January.
Okay.
These were not presented at the 15th.
At the first meeting, right? So at the second meeting it was submitted, there's this copy, but at the meeting a larger copy was submitted to the planning commission.
I don't recall seeing a larger copy. I recall seeing 2 copies that looked just like this.
And then exhibit 7, you have that one? Okay.
That was also presented to us.
So that regrid satellite map, that was at the second meeting, correct?
Correct.
So after the 2 meetings you had, one in December and one in January, did you or any other planning commission member make any written comment or request for modification to the proposed overlay ordinance?
We did not. We were still kind of digesting it. You also presented a drawing, a concept drawing to us for review. Remember that?
Well, that's not one of the exhibits. Then.
No, it's not. How come?
I appreciate you want to explain it. Can you answer the question? You have to just answer his questions at this point. Okay?
All right. What's the question? I will answer.
So I want to just be clear. You nor any of the other members of the planning commission nor its solicitor provided any written comment back to Scranton Materials, correct?
No, we did not make any recommendations. We asked a lot of questions at the very first.
That's not the question I asked.
You did not.
As Attorney Johnson, could you just please answer the questions? I'm trying to give you some latitude, but you continue to put comment, and I'm asking the simple questions that are just asked.
No, we did not.
Okay, thank you. So I just want to be clear. The Ransom Township Planning Commission took no formal action between the December 15th, 2025 initial hearing and the January 12th, 2026 second hearing, correct?
No official action.
No formal action. You didn't do anything.
As far as doing what?
There was 2 hearings before the Planning Commission.
Correct.
Other than your comment that you said earlier that you would not recommend, there was nothing else that was done.
Not that I can recall.
So then basically, just so we're clear, the Township's Exhibit 6, this is all there was. There's no other emails, texts, phone calls, and anything from any member of the Planning Commission to anyone on the board, to the solicitor, nothing like that. That would not be privileged. And then at the,
I don't know if it was a question.
Objection 4, it is a question.
What was, if you could re-ask that last one.
what I just want to be clear on is Township Exhibit 6. This is the only thing that you or any other member of the Planning Commission submitted to the Township Board of Supervisors. Is that correct? I apologize. I thought he had said yes. That's my mistake.
You're talking about the minutes?
This document, this is what, Township Exhibit 6, that was submitted by Attorney Conover.
Yes. Those are the minutes from the meeting.
Right, but well, my question is so that's that. There was no other documents that were prepared, that were submitted, that are not in the record today, that were submitted by you or any other member of the Planning Commission to members of the Township.
No.
Thank you. And then during that last hearing, at the first hearing and the second hearing, members of the public were there. Questions were asked by members of the public. At that hearing, Attorney May was there. He answered the questions of the members of the Planning Commission and the members of the public that were there, correct?
Yes.
And then, we just talked about this earlier, I just want to clear this up. You as the chair of the Planning Commission, your recommendation on behalf of the Planning Commission is not to recommend.
That's the way the vote went down.
Thank you. That's all that I have.
Are there any questions?
I'm going to speak up. Maybe you'll let me know. Just
Do you want the microphone?
To clarify, can you hear me? Okay, so the proposed amendment was brought before the Planning Commission, and we had those 2 hearings that Mr. Sewell discussed, correct?
Yes.
And we can say yes or no on the record?
Yes.
Okay. After that, the recommendation was transmitted by way of the meeting minutes to the township, correct?
Right.
As far as you're aware, there's no other obligations under the municipality's planning code or the Ransom Township zoning ordinance for the Planning Commission to take any additional action, correct?
Correct. We're only a recommending body. We recommend they bring it to us, we go through it, and we recommend changes, additions, subtractions, and we recommend the board what they should do with it.
And you did that here, correct?
We certainly did our job, yes.
Nothing further.
And just so that I'm clear for the record, at the Planning Commission meeting, after the presentation was made and discussion was had, there was a vote, correct?
Correct.
And that vote was announced at the meeting.
Correct.
Okay, and that's what's reflected in the minutes.
That's reflected in the minutes.
Okay. I'm sorry, sir. Are you an attorney? Okay. Do we have any other attorneys in the audience that are representing any of the objectors? Okay, I see no hands. Do we have any objectors that wish to ask questions of Mr. Murphy on cross-examination? Okay, sir, if you raise your hand, come on up. Get in line. come up and take the microphone. Now, here's what I'm going to say. For the objectors that are not represented by counsel or do not have attorneys, just so you're aware, when you're coming up to ask questions of any witness tonight, you are asking questions. This is not the time for you to provide public comment. That will come later. So if you have questions for Mr. Murphy based upon his testimony or based upon the information that's provided, you can ask him questions that he will be obligated to answer. But it is not the time for you to get up and say your piece. That time will come when you are called up during your case as an objector. I just want to make sure that that's clear for the record. Okay, with that understanding, you can state your name and your address, and then go ahead.
John Pachowski. So, Mr. Murphy, being a part of the planning commission, someone submits their plans, and then your responsibility is to either approve or recommend approval or recommend, I should be asking. So I understand
Yes.
your place, or the planning commission's place, is to make your best judgment as to whether to approve something or not approve it.
Right, we make sure that it meets the rules and the regulations as best it does. I mean, it's basically, we review it, the township engineer goes through it, makes recommendations. We make recommendations, it gets changed, amended, then we approve it or disapprove it at that point in time. We only recommend to the Board of Supervisors if they should accept it or not accept it.
So on that application, with that site plan, what are the suggested setbacks to neighboring properties?
Well,
Tell me that, is it in there?
I covered that when I said that, numbers 4, 5, and 6, minimum setbacks, max building coverage, and max impervious does not seem to follow the general commercial industrial zoning rules.
So it's probably less than
It's
what
way
would
more.
be recommended.
It's way more than we would recommend, yes. In the ordinance.
In the ordinance,
Correct. The ordinance that's proposed.
as proposed.
Correct.
Could you tell me what that setback is?
Actually,
So my question is,
they've got percentages in here. They have some, it says you have to read the minimum setback schedules. They got 50 feet or the height of the building, whichever is greater, in addition to a minimum required setback, shall be increased. Okay. They've got data center accessory structures within 50 feet of the building. I mean, within 50 feet of the height of the building. So if the building is 100 feet,
150 feet.
yeah, you got
So I could have
it. You should have way more
a
buildings.
building 2 football fields in size, 150 feet from my property.
Right.
Okay.
Yes. That's the way it's written.
Kerry Carney, you had touched upon it. Is there an environmental impact report, and is it available to the public?
I don't think there is.
Should that be provided to us?
That was one of the comments that I made here.
Thank you.
Mia Ganditos.
I'm sorry, your first name's Mia?
Mia.
M-I-A?
Yes.
Okay, thank you, just so it's clear on the record.
Okay. My question is, on the December 12th meeting, were all of your questions answered and all of the people, were the questions answered clearly and concisely so that we know exactly who's doing what and who's responsible for what expenses? Were all your questions answered so that you can make a very clear, informed report?
I would just make an objection to the question. As far as this gentleman could talk about whether or not he felt that his questions were answered, but I don't believe he can testify as to whether the public felt their questions were answered.
I don't feel my questions being answered.
he can testify as to whether his questions were answered. He can't testify for anybody else.
Was the question asked about the wildlife and what was going to happen to the wildlife in that area?
I recall that question was asked.
And the answer to that question was?
The answer to that question from Mr. May was, if my recollection is correct, that there is no wildlife there.
Exactly.
Are you paying attention to what my answer was at that meeting?
Yeah.
What was my answer?
Is that you don't have enough information. We have wildlife, and we don't have the answers. And we're supposed to make a case, and you're going to decide on this case tonight. We don't have the answer that we need
And again,
to
ma'am,
present.
if you have questions for Mr. Murphy, that's your
Thank
opportunity.
you, Mr. Murphy.
You're welcome.
Thank you.
Hi, Harrison Wolf. Even if this proposed data center met all expectations, all standards, which, well, I'll keep my personal comments out of it. Even if it met all the standards, is it within the right of the Planning Commission to still vote no on this, even if it met all standards?
It could be, it could go either way. I'm only one man. That's why there's 7 members. We usually have a quorum of at least 4.
I guess I'm just asking.
It could go either way.
Okay. I guess I'm just asking because it seems as though we are, the questions about whether or not this center is meeting standards is one question, but I guess my question, and I think you're answering it, is even if it met all standards, you guys still voted no, and that's still okay.
But he can't provide you with legal advice or legal conclusions. He can tell you what is before the Planning Commission, which was the proposed ordinance that was submitted by Scranton Materials. It's not appropriate for him to comment on something that hasn't been submitted to the Planning Commission. He testified that the Planning Commission reviewed it and that in their opinion it should not be recommended based upon the review of the ordinance and the proposed plans. So he can't comment on something that's not placed before him. If I'm following your question, that seems like what you're asking.
I guess I'm saying, like, what if everything in this data center followed the ordinances correctly, the Planning Commission can still vote no.
Speculation. Yeah, and I'm going to grant that objection. He can't comment on what would be on something else that would be submitted. That's not before the Planning Commission at this point.
Okay.
Okay. Thank you. Okay.
You're not testifying.
You can't testify.
Megan Loftus,
Well, I'm sorry, there was a squeak from the chair. What was your address again?
my question for Mr. Murphy is under Section 4, Additional Standards for Data Centers, 802, line 9. Specifies that data center developments shall be exempt from the steep slope provisions of Section 403. Was that discussed in the Planning Center or by the Planning Commission? And is there any precedent for there to be a specific use listed in our zoning ordinance that is exempt from other rules in the ordinance?
Where did you read that?
Well, it'd be on page 7 of the proposed amendment, but it is, I think it was
Number 9 on page 7.
number 9 on page 7. It says data center development shall be exempt from the steep slope provisions. And then goes on, provided that all proposed grading is in accordance with erosion and sedimentation control plan. Blah, blah. My question would be, is there precedent in the township with the Planning Commission or before the Board of Supervisors to exempt specific development, like a data center, from written qualifications, such as the steep slope provision,
just because its use as what its characteristic is?
I don't really have I'm going to be honest with you, I don't have a good answer, right? I did tell you that the lower buildings to the upper buildings as proposed on their concept drawing that was presented to us in January, the elevation changes between the two of them are very concerning.
And because the general public was not privy to the concept drawings, was there any presentation to the Planning Commission on why it is required or needed that the data center be exempt from the steep slope provision?
No.
Okay, thank you.
Based on the cross-examination, any further questions?
No further questions, but I just moved that Scranton Materials exhibits 1 through 8.
I object to those exhibits first on the basis that none of the parties in this room have had the opportunity to review these exhibits. Secondarily, object without having the opportunity to review them on the lack of authenticity. I don't think Mr. Murphy is sufficiently authenticate the exhibits. I haven't seen them, I don't know what they are, to authenticate exhibits, maps, drawings that were prepared by someone other than Mr. Murphy, except to the extent that he can authenticate that it is what he reviewed, not that they purport to say what they're saying.
And I think that you could admit them during your case in chief. I don't think it's appropriate to admit them at this point. So I'm going to deny the admission at this point, subject to during your case in chief, based on what you present, we can make a decision at that point. Anything further from you?
Nope.
Anything further from any of the objectors or their counsel? No? Okay. I'm going to move for the admission of exhibit of Supervisor Exhibit 6, which is the Planning Commission meeting minutes. Any objections to the meeting minutes, Mr. Sola?
No.
Any objection from any of the objectors? Okay. Thank you. You're excused. Mr. Sola, the floor is yours. Or Mr. Johns, I'm sorry, I'm not sure who's going to do this.
At this time, we will use exhibit 1 through 8 previously provided at the prior meeting.
Any objection to exhibits 1 through 8?
I object to the authenticity of the objections that there's been no case and no one case to say what they are and who prepared them and that, and again, that they say what they're prepared to say. And we have not had an opportunity as party objectors to review that.
Any other objections? Okay. The rules of evidence today do not apply under the Municipal Planning Code, so I would recommend that objection be overruled and the exhibits be admitted. Okay, we have to have order. Okay, the objections overruled. Exhibits 1 through 8 are admitted into the record.
Would it be an opportunity for the parties to review these prior to pretty much anything else happening that would require the possible evidence of prosecution?
Are you requesting that they be provided now?
I don't know what's about to happen. I don't know what witnesses that the applicant is putting on. To the extent that there are any questions about the exhibits, my cross-examination would be based on my understanding of it.
We're not presenting any witnesses.
There's no witnesses being presented.
No.
Other than the submission of the exhibits, do you have any additional evidence?
In that case, objection. In that case, then I understand that the rules of evidence don't apply here, but this is a proceeding as a quasi-judicial body. The burden of proof is on applicants to do whatever it is that needs to happen in this hearing for the court to vote. I move then for what is essentially a non-suit on the basis that they provided no testimony or evidence, no information under oath to substantiate the basis of the application. And I request that the board vote on this now on the basis that they have not, on this non-suit basis, presented anything that would substantiate the nature of the request. There's nothing presented to the board to consider.
Submitted the application, the map, and all the supporting documents. That's what they're voting. And also, Kevin, this started, again, that if you follow the order that this went through, we went through the process. There was 2 planning commission meetings. These documents were part, not all of them because of the way they were drafted. This information was submitted. Mr. Murphy testified that he had seen those documents in the past. They were submitted to the planning commission. So, he authenticated those documents because they were submitted in 2 prior meetings.
And when they were submitted, Attorney Bay was present to answer questions, and the application fees were touched.
And the documents that support it, the zoning overlay map, the zoning overlay, all those documents speak for themselves. That's the decision that's being made, on those documents.
To the extent that the planning commission considered any documents, that although a provision that they needed to hold that planning commission hearing, that's wholly separate and apart from what's happening tonight. This is a hearing, the burden is on the applicant to present evidence and testimony sworn under oath, to authenticate their evidence, and to establish the basis for which they speak. They have put nothing on other than to ask questions of Mr. Murphy, who I renew my objection cannot authenticate those exhibits for what they report. Certain he say they are what was presented to him. He cannot confirm that they adequately represent whatever is conveyed in those documents. Again, I've not seen them, don't know what they are. But this is a hearing. Nothing's been heard. They haven't presented any evidence. I think that there's sufficient basis for the board to deny the application without the need for any other testimony or evidence. I don't even know what the testimony and evidence would be in opposition to because nothing's been presented other than the speaker, which I continue to argue can't be authenticated.
How does she want us to authenticate our submission? We submitted an application. It's submitted by us.
All fact witness. The hearing, all fact witness testified to the document.
We're submitting. That's our objection.
And also,
Submitted as part of the record.
and also the documents have been accepted into the record. So the documents are accepted into the record, and the Board of Supervisors.
They cannot cross-examine his attorney, but they're going to be documented for the purpose of me questioning now exhibits that have been admitted into the record that have not had any cross-examination on them. I believe the rules of professional conduct would prohibit either of these attorneys acting as fact witnesses here. They haven't presented it.
And we've already testified there are no fact witnesses.
I don't think they've been heard, and I think that's sufficient for the board to have.
Well, I understand the question. Sorry. I think this is something that requires more research than we have the ability to perform as we sit here right now. So I think that the best course of action, they've had the opportunity to present their evidence, and this is obviously the first hearing where we've had testimony. So I think that we'll take your objection under advisement, and
Mr. Conable, the only thing I would ask, and we're going to go that way, then I would just ask the record to be held open. And if it is determined after we've conducted our research that we need additional witnesses to be present. Yes. All right. So I would recommend that the record be held open, and if you determine that additional witnesses are needed for additional authentication based on her objection, that we be permitted to return with the appropriate witnesses that you deem are necessary to complete the record.
I object to that being wholly inappropriate. You had the opportunity, this meeting was called, and the speedy statute, pursuant to their statements, they were going to follow the 60 case. The meeting was held, they had an opportunity to bring whatever witnesses they needed to put their case on. They didn't bring anybody today. You don't get a second bite of the apple because the quasi-judicial body says we didn't do enough.
But nobody said we haven't done enough. You indicated you need to do more research, and if that's necessary based on her objection, which we could not have anticipated her objection prior to coming here tonight, then we will provide whatever additional evidence or testimony you require to complete your evaluation. And the documents have been submitted into evidence. And the documents are there for the review of the board.
I'll withdraw my objection when if that's the case, if they have the rest of their case, then I'm ready to withdraw my objection and allow them to call their witnesses, and when they don't, I will renew my objection because they don't have anybody here to that.
You need to determine if you feel that, you said you need additional research to determine if witnesses are required beyond the documents that have been submitted as part of the record.
That's not the job of either the legislative body or body sitting in quasi-judicial capacity to provide legal guidance to councilors to what they need to do to meet their burden. That's all I said. If they haven't done it, they haven't done it. And that's why I requested the board make a decision now on the basis that they haven't met their burden of motion to deny. I've never heard of a situation where an applicant or a party to a legal proceeding would ask for whether or not they've done enough, and then be given the opportunity to come back and have a second chance at it.
If you listen to what he said based on your objection, he needs to conduct additional research to determine what's necessary. I'm not looking for guidance. He's trying to rule in your objection.
If research is on the legal basis of whether or not my objection can be entertained by this board, the legal research, I argue, is unnecessary, but whatever, then so be it. However, the research shouldn't be on whether or not they've met their burden, and if they haven't, leaving the record open for an opportunity to do it again. Again, I will withdraw the objection right now, let them present the remainder of their case in chief if they haven't rested, and when they rest, I will be prepared to make this objection in probably a few minutes. I'm prepared to do that.
Maybe. You might not get an answer. Okay.
I understood from the last meeting that what had happened last meeting, we had was that you were trying to get to the planning people and that the decision and then and so from what I understand
They presented their documents, but they don't have witnesses. Here's what I'm going to do. I'm going to close the record briefly while I go into the other room by myself to review the requirements in the municipal code. And then I'll come back and make a recommendation. Okay? Well. Subsection 6 indicates formal rules of evidence shall not apply. Irrelevant, immaterial, or unduly repetitious evidence may be excluded. Given that, I am going to recommend that the supervisors deny the motion for a non-suit and that we move forward with it. How do you vote? Thank you.
I'm kind of with her on this. I mean, like when the solar people came to present their case, they had the environmental study done, they had the hearing study done, they had the layer study done, they had all all the ducks were in a row, and they had professional people in that area to talk about it. I think they're going to present their application. They should present it with all the things that are required to come with it. All
So how do you rule to grant the motion or to deny the motion?
Grant her motion.
Grant the motion and the application is dismissed. Okay.
Is the application denied? Is it denied?
Two different things. You ask for a non-suit.
The motion for a non-suit is granted. And I believe that essentially dismisses the application because they failed to submit the appropriate record. You had a comment.
Yes, Mr. Conley. Just for purposes of the record, I'd just like to point out the fact that the items that are listed, exhibits 1 through 8, exhibits 3 and 5 are emails from you, which have been submitted as part of your record. 8 is the zoning ordinance, which stands on its own. So the proposed overlay ordinance, the application, the zoning overlay, the survey map, and the aerial map are the items that we attempted to submit as exhibits. These items were previously submitted to the Planning Commission pursuant to the directions by the township at 2 separate hearings. They were accepted, they were reviewed, and they were used as the basis for the Planning Commission to make its determination. The chairman of the Planning Commission, Mr. Murphy, was here. He testified that all the items 1 through 8 were previously presented and accepted into evidence at the Planning Commission meeting and were used as part of the determination that the Planning Commission, part of the factors that the Planning Commission used to make its recommendation. So based on the fact that these items have been previously submitted to a township board, they were accepted into evidence and were used for purposes of determining the final outcome of the recommendation by the Planning Commission, and that Mr. Murphy testified that he was provided all these items, he was authenticated that they were previously submitted to the Planning Commission, that they should be accepted here, and they should be used by the board to make its determination just as it was used by the Planning Commission.
And that's noted for the record, but the decision time. Okay, that concludes the hearing. Thank you.